So Dr. Vanna, are we going to have the Q&A in the later part?
Yes, sir.
Oh.
We will have Q&A after your talk, and because it will be better in case if there is any pressing question, they can raise their hand, but prefer to have Q&A after the session.
Yeah, sure. Thank you.
So I can see Dr. Shashendu Mukherjee has joined. So, sir, Dr. Pandey is with us.
So yeah, we had a small chat. Yes.
Yeah. Just so, Vinita, can we start or wait for 2 minutes more? It is still 2 minutes to 4.
Yes, sir. We can wait for 2 more minutes and then we will start.
Sure. Yeah, we can wait.
Vinita, we can start now.
Yes, sir.
Over to you.
So, thank you, sir. So, first of all, on behalf of BIREC, we would like to welcome Dr. Pandey. And BIREC has in-house IP and technology management group. And every year we conduct a series of webinars, or we used to do the workshops in person, but because of the corona thing, we are doing webinars. So every year we conduct such programs that includes not only the awareness program or sensitization for the participants or the startup companies or students, but we also plan and do the capacity building programs or the theme-based program where the participants from different categories like startups, entrepreneurs, they used to learn about how a specific technology will have the IP involvement and IP related matters. So this is the first of the webinar which we are conducting for the year, and now we have today Dr. Pandey, and thank you, Dr. Pandey, for joining with us. And this is the webinar which we are starting with the patent process and strategy. And so I would like to request Dr. Mukherjee to give the brief introduction about the Dr. Pandey so that we can start the today's session. And we have participants from like different, again, they are the postdocs, or they are the students, and they are coming from the startup companies as well. So it's a mixed lot, and hopefully we will have an interactive session for this webinar. And also for the participants, a small thing, in case you have any question, you can raise your hand, or you can always type your question in the Q&A box, which is there. You can see on your left hand side. So, sir, may I request you to kindly introduce the Dr. Pandey for the session. Over to you, sir.
Thank you, Vinita, and my colleagues in BIRAC, Vinita, Amit, and Sanchita. It's my pleasure firstly to welcome Dr. Pandey as well as all the participants to the series of webinar as Vinita described. As you all know, BIRAC is a public sector undertaking under the Department of Biotechnology, Ministry of Science and Technology, Government of India. And our job is to enable innovation, enable the innovation ecosystem in this country, and through various mechanisms. And funding is one of the mechanisms we do, and that is almost 60% of our work. But 40% of our work is to enable, not only fund, but to enable the ecosystem, the innovations to go to the next level through patent support, helping in patent management, identifying innovation, taking the innovation to the next level, to the technology transfer process, to regulatory approvals, and finally to design the exit strategy and enter into the market. So I think this entire life cycle of the innovation, BIRAC and BIRAC team members literally enable the ecosystem as well as the individual innovators and the applicants to go to the next level. And the specialized services group, which I, Vinita, Amit, and Sanjay all represent, Sanjay represent, is one of the key pillars in BIRAC, which really helps the other main divisions in BIRAC to enable the ecosystem. And this series of webinar, which Vinita described, is to help our applicants, our grantees, prospective applicants, and students, the academicians, to get to know a feel of the innovation ecosystem through the enabling processes of patenting. Patenting, as you all know, plays a very critical role in enable the ecosystem to have commercial exit into your innovation, which is very, very essential to build the enterprise and to take your innovation from really bench to the bedside or to the lab to the field, which is a very critical tool, patent. And today's seminar, patent processes and strategy, really will help us to understand processes and strategic decision to file for patent. I think that is very, very critical. Everything which patent is an instrument or a tool which really helps you to take your intellectual property to a level where can it have a commercial exit. And I am thankful to KNS partners and Dr. Sachindra Pandey, who has really agreed us to join this webinar today on our request. And definitely during the webinar, I will advise all of them to be interactive, to ask questions, to clear your doubts, because we have a very eminent faculty today, Dr. Sachindra Pandey, who has a very strong experience in moving innovations through the IP tools. Before we start this webinar, I have the pleasure in introducing Dr. Pandey. So Dr. Pandey, as we all know, I said that he's a partner with the KNS and partner Gurgaon, and he's an expert, and his niche area is life sciences patent domain. He's expert in the life science patent domain with key interest in areas like microbiology, biotechnology, molecular biology, biochemistry, pharmaceuticals, diagnostics, chemical sciences, nanobiotechnology, which I think biomedical engineering. So I think the entire gamut of life sciences, not only the life sciences part, but also medical technologies included into it. And we have a very excellent faculty today. I think we should all use the maximum of his expertise today to understand the process. He has been a very strong experience in handling drafting, prosecution of Indian as well as the PCT application as well, both in US Patent Office as well as European Patent Office. And he appears regularly for hearings in all these offices. So you have literally a person who will handhold and who has hands-on experience to do it. And he speaks at various conferences. You all know he's a very familiar face. He is a very strong expertise in that. He has several peer-reviewed research articles to his credit, and he has been professional membership of various organizations, Bar Council of India, the Biotech Research Society, Indian Academy of Environmental Sciences. So we have literally proud and honored to have him with us today. And I will, without much ado, I will request Dr. Pandey to give his, talk to us and enlighten us in the patent process and strategy and what are the ways we should strategize this. Over to you, Vinita. You have something, or I'll request Dr. Pandey to start his presentation.
No, sir. We can request Dr. Pandey to start the session.
Dr. Pandey, over to you.
Thank you, sir. Thank you. Thanks a lot for your kind words. You have said a lot about me. Maybe I'm not that worthy, but yeah, I'll try my best. So thanks to you, thanks to Dr. Vinita for giving me this opportunity. And I was telling Dr. Vinita that it is sort of a homecoming for me, because I did my PhD at PUSA and continued my postdoc at ILS, so which is a DBT institute, and I could personally see Dr. Manju Sharma and Dr. M.K. Ban, Dr. Renu Swarup, Dr. Rajesh Gokhale as our SAC committee members. So, and as you all, I have been through the grind of research. I felt the pain of researchers. I felt the issues they face, like the fundings, maybe the chemicals which are required, timely required for research. All those issues I've faced. And after I did my postdoc, I joined here in KNS in 2013. So since 2008. So since then I've been associated here, and I've grown here from an associate level to the partner level. So the firm as such works in all spheres of IP, like trademarks, copyrights, patents, and I particularly am in the patents field and specializing in the biotech life sciences field. So maybe this is my brief intro, and maybe we can proceed further with the topic of today, which is very important topic. And sir, I've felt through these years that the perceptions, the things have changed. Like when we were doing research, you are much more senior to us, but when we were doing research maybe 15 years back, people were not that aware. People were going for publications and all those type of things, but now we ourselves have seen a shift. We have seen a shift that people are concerned, they're aware that they should go for patenting first rather than publications, which is a important issue with all the researchers. So maybe we can continue. So the topic for today is patent process and strategy, and what we are going to cover is the filing of the patents, the process which is followed, and the process which is followed by the patent office. And maybe I'll give you an idea about the rules, new rules that have come up in 2021, which have actually helped the educational institutes and particularly startups and women entrepreneurs. So that's an important thing. Then, because of the virtue of having worked with CSIR and IITs and ICMR, our firm is well versed in like filing PCTs and filing patents outside. So maybe I'll give you an insight about that, and then maybe we'll talk a little about the management of patent portfolio. So we can proceed further. Yeah, please. Maybe you can change the slide. Yes. Yeah. So maybe before going to the patents, I'll say that one or two slides will have for IPR as such. So IPR, which is an intellectual property, like which is the bucket of intellectual property rights. So these are the rights which are created by our intellectual property. We have thought something, we have had an idea, we have put that into practice, we have made a device out of that, or maybe we have developed a new process for that. So that idea, which is not in a physical form, probably like physical form of a sort of a home, but or a property which is there in a tangible property which is there, which we can see. So IPR is like a idea which has been generated in mind, and that has been put into practice, and some product has come out of it. So intellectual property is creation of human mind, and there are specific rules to protect that. And so we have so many acts to do that. Like we have a patent act, we have a copyright act, we have a designs act, we have a biodiversity law. All these are very important. And over the years we have felt, or any attorney would have felt, and any institution like BIRAC would have felt, that it is like a real estate. It should be developed well, and then we should define it well. We should also protect it, and then keep upgrading. So we like there is no bar on getting improvements patented. So a technology which is there can be improved, and a next generation of patent can come out of that. So it has to be developed, it is to be managed well, and with every patent portfolio becoming big, the value of organization or a company also increases. So it is an asset which we should develop and protect anything. And any big company or any big organization, say for example Google or Amazon, they are well aware and they know that they have to work on IPR and develop it fully to get the potential out of it. So next slide please. So as we were talking, there are various forms of IPR. So patents, trademarks. So patents are given for new inventions. Designs are given for changes in the aesthetic sense. Say for example, you have 3 or 4 types of chairs. So the function of a chair remains same, but the aesthetic value or the aesthetic look of that chair changes, and we can get a design protection for it. And then one of the important IPRs could be trademarks. Say for example, a logo of a Coca-Cola thing or a Pepsi thing, we can just recognize Coca-Cola by or thumbs up by seeing that sign. So that is a very very important valuable asset if we talk about IPR. So patents or a trademark or a design, these are very important, and they all go hand in hand. So when a company thinks of developing an IPR strategy, they think of developing all these things: patents, copyrights, trademarks, trade secrets, plant variety, especially for plants, because plants as such are not patentable in India. So there is a different provision for that, for the protection of plants per se, and that is under plant variety protection. So next slide please. So I'll read out 1 or 2 statements for you, like the way people have recognized and valued the IP. So I'll read out a statement from the president of Coca-Cola company. He said that if each building, factory, office, car, truck owned would burn down in a moment, these are all physical assets, the company could get back to operational rebuilding and buying everything lost in 1 year due to the profit and value generated by the IP. So such is the importance of IP, and people do, big companies do realize that we need to encourage filing of IP patents and nurture them in a way that they can yield best results. I'll read out one more statement for you, that if this, which is from chairman of Quaker. So if he says that if this business was split up, I would give you the land and bricks and mortar, which is all the physical things, and I would take the brands and trademarks, and I would still fare better than you. So this is the thing, the importance of IP. And maybe the last statement I'll read out for you, which is important for us as researchers who have been in research or who are in research, that to achieve patent commercialization success, every inventor must think like a businessman. So maybe down the lane, the people who are into research these days, they can start thinking, say for example, they can start thinking of making their own startups. They can start thinking of developing new products and take them to market. Think like businessmen. So yeah, next slide please. So maybe now we transit into the main topic of today. So what is a patent? So it cannot be an interactive session, but hopefully next time when we meet, Corona is over and we are able to meet physically, and then interaction will be much better. However, let's start with the main topic of today. So what is a patent? So patent is an exclusive set of exclusive rights. It is a monopoly given to you by the government. So any government of India or government of US or government of a European country, for to an inventor for detailed public disclosure. So here we have 2-3 things to know. One thing is that it is an exclusive right. It is your right. You can sell the product, you can market it, you can license it, and this protection is not for whole life of yours. It is for 20 years, because patents cannot be given for whole life. Like copyright, they have a larger protection, but the technologies keep changing, so the time has been fixed, the volume is fixed, and the protection or the rights you are given is for the detailed public disclosure. So when we as attorneys write a patent application, we give all the details, that what was the problem in the background, what is the problem I have addressed, how I have addressed it. So all these things are to be given in writing in a patent application, and that would be a public disclosure which will be available at the patent office website itself. For this public disclosure, the government is giving you these exclusive rights or monopoly for 20 years. Okay. And so another important thing here is that India as such, and most of the countries, they grant patents on product and processes. So there are some other countries like Europe, they also grant patents on new use or something like that. We don't grant patents on use of something or new use of something, but if there is a new product or there is a new process, say for example, if someone comes up with a new machine for doing a PCR, and he develops a new PCR as such, or a process for amplifying DNA, that will be patentable. So India grants patents on products per se and the processes thereof. Another important thing here, maybe important for our listeners, is that patent is a territorial right. So territorial right means that it's not that if I file an application in India, I get the right in all the countries. Say for example in US or Europe or anywhere else. So if I have applied for a patent in India, I will get the protection in India only. It is a territorial right. If I have applied for a patent in US, I'll get the protection only in US. So this has to be kept in mind. Sometimes it happens that people are under perception कि मैंने तो India में file कर दिया, so I have protection all over. It's not that case. So patent is a territorial right. If we want protection in different jurisdictions, different countries, then we have to file separate patent applications in those countries. So this has to be kept in mind. Another thing maybe is that it is a negative right, like you are excluding others from making, using, offering for sale, selling or importing the patented invention. So you yourself can do that, but main purpose of a patent is to stop others from using this technology. So we also call it as a negative right. So next slide please. So maybe this is important for our researcher friends. So many times it happens that people come to us that I've discovered a new organism probably which was there in a soil or maybe a contaminated soil. So any such discovery which is there already existing in nature, so such type of things will fall under discovery or a mere discovery and are not patentable. But if there is a human intervention, so if for example you mutate that microorganism and you generate something out of it, then it will be patentable. So there is a difference between an invention and a discovery. So discovery will be that which is already there, you have just noticed that. Say for example Newton's law. So Newton watched that apple fall down and he got an idea, oh, these are the things, these are the three laws. So like coming onto those three laws as theory was a discovery or a postulation or a hypothesis. But when someone made a rocket out of that you need to give a thrust and overcome the gravity. So he is working with the patent with Newton's laws. So when a product comes out of those maybe formulas or scientific principles, then only it becomes patentable, or then only it becomes an invention from a discovery. So until and unless it is in the form of a formula or a scientific principle, it's not patentable. So only inventions are patentable. Mere discoveries as such are not patentable. So we can go to next slide. Another important aspect, like being in research, we are aware that we have pressures. We have our own pressures that we have to publish our patents. Next slide. We can go to the next slide. So we have often in a firm talked about this theory that people usually will go for a so whether we should go for 2P or a 4P. So 2P will be publish and perish. So as soon as you publish your paper, that is in public domain, and then you cannot file a patent on that, as such, that paper. So it is better that you go with 4P, that you first patent, and every patent gets published. So every patent gets published in 18 months. So you file a patent, it will get published, or even you can publish on your own paper after you have filed the patent. So whether it is a provisional patent or a complete application. So we'll talk about these two terms, provisional and complete, later. So I think it is very much pragmatic that we first file a patent, let it get published either through patent office, or we do our own publication as an article. We get profit out of it, like we license it, we make the product, we sell it, we get profit out of it. And because the patent has a term of 20 years, it will perish on its own. But until that, we will have had some profit out of it. So it's always better that when you feel that there is some merit in your invention, please go for filing a patent, even though it may be a small provisional patent. File it, publish your paper, file a complete application out of that provisional application. Maybe try to so BIRAC as such is a good funding agency. We can coordinate with funding agencies like BIRAC or TIFAC. Profit from that patent by licensing your technology, selling your technology, and then maybe you will perish. So even after 20 years, no one is stopping you from selling your patent in the market. Yeah, your product in the market, it will be there. But the because of the 20 years span being fixed, you may lose that thing, but definitely the product will be there. We can go to the next slide. So how we as such attorneys will look at a patent, or how maybe a new inventor would look at a patent, is that any patent on or any patent drafting depends on how we have understood the problem in the prior art. So prior art means which is already in public domain. So public domain means the articles or the patents which are already filed, which are already available to public. So there are like problem. So say for example, I'll give you an example of PCR only. So first time the PCR was filed, maybe the inventors had a big problem that how they could amplify the DNA. So that there was no patent already existing on that. There was a problem. They addressed it by developing the PCR technique. Now when this PCR came into market, or came into research, people face a problem that ठीक है, DNA amplify तो हो रहा, but it's not so purified, or the volume of DNA which I require is not that much. So then again there is a problem in prior art. So there is a problem, and now I again develop a PCR on that basic PCR, which is able to amplify the DNA in a greater amount, and which is able to give me a purified DNA. So like the goalposts also keep changing. So maybe there is a basic patent, we can keep improving on that patent. We need to keep in mind that whenever we write a patent, or whenever a researcher works on a problem, so there is a problem, and if we have a solution, there is a possibility of filing a patent on that. So next you can tab on. So 2-3 things. Yeah, one more. Yeah. So patentability will depend on, so it is like these criteria which I mentioned here are universal criteria. So for getting a patent granted, you need to show that it is novel, that no one has done it before. It is non-obvious. So maybe here I'll elaborate more on non-obviousness part. So many a times it happens that people come to us here ki I've developed a new product, I've just changed or maybe I'll give you a basic example that say for example there is a pen and someone adds a cap on that. So he has made a novel product where cap has been added, but whether a person who is working in the same field, can he visualize that? Most probably he'll be able to visualize that yes, there I can add a cap on on a pen so that the ink does not disappears or easily or quickly. So one criteria was addressed of novelty, but maybe it was obvious to a person skilled in art, and probably in that case you may not get a patent. So for getting a patent, these three criteria are important: novelty, non-obviousness, which we'll talk about later, and industrial application. So every patent, like has to have industrial application. If it does not have industrial application, we cannot replicate it or we cannot mass produce it. It is probable that patent office will not give us a patent. I'll give you an example here. So I'll give you a live example. We were handling a patent for CSIR, where they had found out a gene which was capable of inducing freeze stress tolerance. So that plant existed in higher Himalayas, and that plant had a gene which could induce freeze stress tolerance. So the inventors found out that, oh, okay, there is a plant which can grow in snow, and then they could identify a gene which was responsible for that activity. So that was a discovery. Till then they did a southern blot, they did everything. They filed a patent for that sequence of that patent. So earlier, like India does not allow patents on genes and proteins per se. If they are naturally occurring, they are not allowed in India. They are not allowed in US even now these days. Europe does allow such patents. So that was a patent prior to 2013, when US used to allow genes, naturally occurring genes. So we had filed that patent in US. So what the examiner said about that patent was that, I agree that there is a novelty, there is non-obviousness, but you have not made any transgenic plant. That means you have not shown me the industrial application or utility of this patent, of this proposed patent, and they were going to reject it. Luckily, what happened that the inventors could make a transgenic plant. We submitted that data in a continuation application in US, and we could get through. So like, you can keep in mind that whenever there is a patent application, you need to satisfy these three criteria. That means novelty, non-obviousness, and industrial application. Maybe Amit, you can tab one more. Also, patent grant will depend on local laws also. Especially, India has a section. Maybe you can go through it later. So we have a section 3, which which mentions those things which are not patentable. Say for example, that if there is a method of treatment, it is not patentable here. If there is a traditional knowledge, it is not patentable here. So local laws also play a role in granting of a patent. As I told you, India does not allow use or new use of anything, but Europe does allows. So if you have invented something, um, say for example, I'll give you the example of aspirin. So earlier, we all know that aspirin was used to cure headaches and all. So that was the first use for which aspirin was discovered. The inventors got a patent on that molecule per se and that use. Now again, after maybe 10-15 years, another use of aspirin came up, which was as a blood thinner. As we know, we usually use it these days for thinning the blood. So such a new use, it is not patentable in India, but it is patentable in Europe. So I mean to say by this that local laws also affect how or when a patent will be granted. So maybe we can go to the next slide. So as I told you, India has a section. We have a section in our Patent Act which mentions that we get a patent on a product and a process, and we need to show that there is an inventive step. So inventive step means that it should be non-obvious, and there should be some technical advance over the existing patents. So these are the few criteria on which patenting will depend, and these criteria like novelty, inventive step, and industrial application, they are fixed. They are fixed all over the world. So local laws may change, but these criteria are universal all over the world. So we can go ahead. So so there are many things which are not patentable, but there are many things which many of the things are patentable. So like we were talking, that if we develop a new PCR machine per se, which is a product, or we develop a new chemical entity, say for example a new anti-cancer drug, a new molecule for treating AIDS, so such a drug or such a machine will be patentable in India. Then there is one more category which is called composition of matter, and which may be important for many of the researchers here in our biotech domain. So composition of matter is that I take neem, I take haldi, and maybe I take some other plant, and I just grind those leaves and I make them as a composition. So I don't know what is the active compound or active component in these two separate things. Maybe azadirachtin may be there in the neem, or curcumin may be there in haldi. I don't know. I've just mixed these two things and I've made a composition which is showing great activity, maybe wound healing or anti-cancer activity or whatever, and it is also industrially manageable and producible. I will get a patent on that, and that is called a composition of matter, where I don't know what is the active compound. So we do get patents on composition of matters also, although as I told you that here we may, like in this particular example where neem and haldi are there, we may face a local law of saying that traditional knowledge is not allowed. So maybe if I find something new, if I add more components onto this composition and prove that it is not a traditional knowledge, I will definitely get a patent on that. So I get a patent on product, like a new chemical entity, a machine, a process, as I told you that a new process of making amplifying DNA, or maybe a new process of treating sewage sludge. Say for example, I find a new microorganism and I mutate it. So naturally occurring microbes are not patentable in India, but if I mutate a microorganism and I get a new process where I change the temperature conditions so that this microbe can grow, and I can direct this process to maybe treat a sewage sludge or a product from a distillery which is black, and with this microorganism I can remove that black color. So such a process will be grantable, and if that microorganism per se is mutated, I will get a patent for that also. So as I told you, there are local laws, like must be a statutory subject matter. It should not fall out of purview of patenting. It should not fall under the category of being non-patentable. Another important thing is that mere idea. So if someone comes to me and says that I'm proposing a machine, or I have in mind to develop a new process, so until and unless we do some functional analysis of it, so a mere idea which is in air, that may not be patentable. So we need something tangible in hand. So mere idea is not patentable. You need to show some experiments, you need to show something that, oh okay, it's working. So whenever we draft a patent also, we need to give working examples in that disclosure. So a mere idea is not patentable, but yes, products, processes, machines, all these are patentable in India also, and almost everywhere. Yeah, you can go to the next slide. So if we talk about maybe electronics or software per se, so method, where we are talking about India maybe initially. So in electronics, methods and processes are allowed, apparatuses and devices are allowed, network connections and all these things are allowed. But if you are asking for algorithm per se, or a software per se, which is just a written instruction as to how a computer will function, so that software per se may not be allowed. But if you are going to show that with this software my hardware is giving me some such function which was not achievable earlier, then this software in combination with that hardware will be patentable. So software per se won't be patentable, but yes, a software along with the hardware will be patentable. And this issue would be faced by people from our bioinformatics background. Then mechanical, any assembly, any method or any device, these are patentable. So we can go to the next slide, please. So biotechnology, we do have challenges in biotechnology, especially in India. So what is allowed here is a modified microorganism would be allowed, a naturally occurring microbe will not be allowed. Methods and processes are allowed. Modified genes and proteins are allowed. Antibodies and enzymes also are allowed, but for antibodies we need to have sequences in hand. So if we have sequences of our maybe heavy chains or light chains, definitely we'll be able to get a patent on an antibody. Then in pharma and chemical, any new chemical entity, as we were talking, any new drug for treating AIDS or a cancer or any other thing, composition of matter methods, drugs, they're allowable. Kits do fall under some gray area, like sometimes some of the examiners may not allow a kit. They may not allow such a kit which is just comprising of known components. So if you have some component which is a new component, and so there are fair chances that a kit also will be allowed. We can go ahead. So life cycle of a patent, as as we were talking, that 4P, you should file a patent, maybe then publish the thing, exploit it, and then let it phase out. So like a butterfly has a cycle, that egg would go into larva and pupa and adult. So patents also have their own life cycles. So first thing will be when a patent is conceived. So maybe you get an idea in your lab while you are doing something, you face a problem in lab and you want to address it, and you find out some solution. So that is the basic thing where conception of a solution will be there. Then maybe you will come to an attorney, or maybe you can draft it yourself if you are comfortable with drafting. So conceiving of an idea and getting, like, taking into practice, drafting it, and then filing it. So filing also is not a simple process. So we have some forms which are there, where we need to there are many patents which have been rejected just on the formal side, that the formal things were not completed, there were no signatures of the inventors, or like we had not given the details about any other formal things. So filing of a patent with proper forms is also important. Then that patent will get itself published after 18 months by the patent office itself. After the publication, what will happen, that the examination phase will start. So the examiner will generate an examination report, he will give it to the controller will issue that examination report, and we have to reply to that examination report within 6 months. Plus 3 months also extension is allowed, but that is payable. So basically we should go for filing a response to the examination report within 6 months of issuance of the first examination report. Then there is a possibility that with your answers, with your response to the examination report, a patent office will say, okay, I'm satisfied, and they will grant it. But there are chances, and especially in biotechnology, there are many cases where we do get hearings. So the controller will call us for a hearing. There are some lacuna, I want you to modify the claims. So we have to attend the hearing, and then this patent will get granted. And with the grant, what will happen, you have to pay annuities. So it's not that once you have got the patent, it is yours. So if you want to continue that patent for 20 years, you have to pay annual annuity to the patent office. So you have to keep paying that annuity simultaneously, and you can now sell the, once your patent is granted, please proceed to like launch the product in market and exploit it. So yeah, we can go ahead. So I think this is one of the important slides here, where we will be able to know how the patents can be filed. Say for example, if I have filed a patent in India, now what routes I have to go into other countries. So what will happen, that there are two types of application. You would note that I have mentioned there. One is a provisional application, another is the complete application. So provisional application is usually done when we see that we have some preliminary experiments, we have some data in hand, but we are still feeling that no, I have to get a patent, I have to get a priority right on my patent, but I have to do some more work on it. So then in that case, you will go for filing a provisional application, which I have to complete in 1 year, which I'll call a complete application. So usually in India, we will not file the like we will not add the claims while filing the provisional application. We will add the claims only when we are filing the complete application. This is because we are aware that the inventors may be doing some experiments, and the scope of my of the scope I want may change, because as attorney, it is my duty that I should get the broadest possible scope for my inventor. So that is why we wait for 1 year, like when we file the complete, then we add the claims there based on the data which we have, based on the experiments which we have. So these are two types of applications: provisional application and a complete application. So and सारा खेल जो है वो priority date का है. So as you will note in next slides also, we in India and in almost all the countries, we have the system of first to file. So whosoever has filed the application first, the right will be hers or his. So even if you have done some experiments and you have failed to file a patent in time, you are losing your priority. And that is what we should keep in mind, that if we have some idea, we have some experiments going on, let us go for filing a provisional application so that we get the priority date, we get the advantage of priority. We can follow that up with filing of a complete application. So this is the route which we will file, like while filing, we'll follow in the Indian application. So if an inventor feels that he has some more data to add, we'll suggest him to file a provisional application followed by a complete application. So that complete application has to be filed within 12 months, like 1 year of the filing of the provisional application. Now another section comes that I want to take my patent, Indian patent, into another country, some other country. So now what options do I have? So I have two options in that case. One is the option of filing a patent through convention, Paris Convention, we call it. So like India is a party to Paris Convention, and India is a party to PCT also. So we are part of PCT, we are part of convention applications. So if you so why one will choose a convention application over a PCT or a PCT over convention is that like it should be a criteria, like when we are filing a patent, we should assess what are the markets which we are targeting, what is the jurisdiction which we are targeting. So if there is a scenario that I want to file patent in only 1 or 2 countries, then maybe I'll go with the convention application. And if I know that my patent, say for example, it is on a new chemical entity or a new mobile, so that new mobile is going to be used everywhere and anywhere in the world, that anti-cancer drug is also going to use everywhere and anywhere in the world, in that case I will go for a PCT application, which gives me broader coverage and which also gives me additional time. So like complete is to be filed within provisional 1 year of filing of a provisional application. Similarly, a convention application also is to be filed within 1 year of the first filing, whichever it is. So it may be a provisional application or it may be a complete application. You have to file the convention application within 1 year of filing of the first application. So in filing a convention application, the only loss is that we get only 1 year, but the profit is that I know that I have to enter into only 1 or 2 countries and I don't have too much of funding. Then I'll go with a convention filing. If I know that I have funding and I want some more time to decide, because like PCT application offers me 2 things. So what happens that PCT application has also to be filed within 1 year, but while filing the PCT application, when you file a PCT application, you get an international search report which tells you the value of your patent. So like advantage of filing a PCT application is that you get an international patent search report, and you get additional time. So for a convention application, you have only 1 year from the first filing, but if you go through the PCT phase, then you have 30 months. That means you have at least 18 months more than convention phase filing, and you have the opportunity to enter into many countries with this PCT application. Whosoever country is part of the PCT route, PCT treaty, you are eligible to file your application there. Only thing is that you need to have funding in your hand. So these are the timelines you can keep in mind, that once you file a provisional application, that complete has to be done within 1 year. Once you file the first application in India, and you want to go through convention route, you only have 1 year to do that. But if you want to have more time, if you want to get an international search report, opt for PCT application. That will give you better coverage, and that will give you more time also, and that will give you more time to assess your patent also. So maybe these are the important things we can talk here, and like when we go into the Q&A, we can discuss it later also. And feel free to come back to me through the mail ID if required. You can go to the next slide. And any possibility if this could increase, if it is visible to all, it's good. So this is a flow chart how an Indian application, what is the life cycle of an Indian application. So what happens that once an application is filed, as we were talking, it gets published. So 48 months from the priority date. One important thing here in India is, in everywhere is that once you file a patent, it's not that the patent office will pick up your application for examination without your requesting it. So you have to file a request for examination to ask the patent office that by please examine my application. So if you fail, so I'll tell you about 2-3 deadlines, which are such deadlines that if you fail to meet them, your patent gets lost. So if you are unable to file a complete application within 1 year of a provisional, your patent will get lost. Like patent office will refuse it, they will not accept it. If you fail to file a PCT application within 1 year of your first filing, the WIPO will not accept it. Another important deadline here is that if you fail to file request for examination within 48 months of the priority, the patent office will not examine your patent and they will abandon it. Your patent will lapse. So requesting for the examination is important step. Only after that the patent office will pick up your patent, your application for examination. So once you request it, once 18 months are over, then the patent office will issue a first examination report. And as I told you, so that first examination report will contain various objections. So that will contain objections on novelty also, inventive step also. So what the examiner will do, they will do a search on their own, and they will try to find out some documents which are important, for relevant for inventive step or novelty. They will cite those documents. You have to reply to them. They will also cite section 3. Say for example, if you have a claim on new plant, they will say that no, it's not a patentable matter. If you have some maybe claim on traditional knowledge, they will say it's not patentable. So examination report will contain all these objections. You have to reply within 6 months. If they are satisfied, they will probably proceed to grant the case. If they are not satisfied, they will offer a hearing to you. So this is the normal process. 2-3 more important things are here, that once a patent gets published, so the public comes to know that, oh, okay, this patent is coming up, this application is coming up. So there is an opportunity for your opponents to oppose it. Say for example, someone has stolen your research and filed a patent. You are not aware, but once that gets published, you become aware. You can file a pre-grant opposition to that patent application, and the patent office may refuse it. So there is one provision of this pre-grant opposition which will come into view only when the patent gets published, the application gets published. So this is one more provision in India which is of a pre-grant opposition. Then there is one more provision, which is a post grant. So if, for example, your patent gets granted, everything is done, you have replied to the examination report, patent gets granted, and now your opponent comes to know कि यार ये तो मेरा चुराया था, he has stolen my data, this was my invention. Then also you can oppose it. But it's difficult to get a post grant application granted, and so if you are aggrieved, you should better go for a pre grant opposition. So this is the normal process how a patent will flow in India. You file it, file a request for examination, it will get examined, you will get an examination report, reply to that, attend the hearing. If issued, it will get granted. Now phase comes of maintaining it. So as I told you, 20 years, like patent office will has not granted you that right free of cost. You have to pay that annuity every year. So keep paying that annuity, keep selling your product and maintaining your patent. So this is the normal flow of a patent. And if there are any questions further, we can go on for discussing them later. So we can go ahead, please. So this is also one of the most important slides. Most of us do face this problem of funding. So while filing a patent in India, you may require maybe 1 lakh or 1.25 lakh or something like that in your hands. So filing stage will include drafting of application and filing it with all the forms. Then there will be prosecution stage, which is the examination stage, and then there will be grant stage where annuities are there and all these things are there. So you can say that you will need now the patent office has reduced the fee, but still you can take that around 1 lakh would be required to file and get an Indian patent application. Similarly, in US, that cost will be much higher. It will be around 8 to 12 lakhs. In Europe, it will be maybe 12 to 15 lakhs. In Japan, it may increase because of translation costs. But this is the reality, and that is why we need to have fundings in our hand. So I think arranging the fundings is very, very important. So maybe we can proceed further. So who can apply a patent? So in India, any person who is an inventor can himself file it. He can file the application through his university or his company or any applicant to whom he wants to assign. So you yourself as inventor can file it. Your assignee, which would be your company or your institute or your or your university, can file it, and any of your legal representative also can file it. So you yourself can go and file a patent at patent office. If you are able to draft it, you can go and file. You have to just pay the official fee. But if you go through a law firm or a patent attorney, their professional fee also may be involved in drafting a patent. So, the next slide, please. So when to apply? As we were talking, whenever we feel that we have some data in hand, we have some indications in hand, let's go for filing a provisional application. So as I told you, India has first to file system, and it is almost everywhere, US, Europe, everywhere. Whosoever files the patent first has the priority, has the right. And for an attorney or for anyone, it is important that we should draft it in such a way that we get the broadest possible scope. So when to apply? Whenever there is an idea which is in the execution stage, you have done some experiments, file it. If you have some whole data, you file a complete application. If you have somewhat data which you are continuing with and which you feel you will complete in 1 year, file a provisional application. So another important thing, as we have already talked, is file a patent before sending anything for publication in a journal. And don't display also. Many times it happens that we display on our websites. So we have had instances where we have stopped like reputed institutes also. What they had done, they had projected that research on their website, and then they realized that they could have filed a patent for it. So no display on the websites, nowhere. File the patent first, then display it. Then display it by means of a website or a poster or wherever. File the patent first, then go for a publication, then go for a public display. Next slide, please. How a patent is filed, as I told you, you yourself can draft the application. You can come to an attorney like me, or any other law firm. uh, it is necessary that we do proper searching. So before drafting an application, I need to know what was there in the background, what were the problems in the background, and how the inventor has addressed it. So that is why drafting is very important. Searching part is very, very important. I have felt over the years that every student, when we write a synopsis for our MSc or our PhD or anywhere, we should go to the respective patent office websites. We should see what type of patents are there, then maybe develop our synopsis. And like searching, that is why is very, very important. Search properly, draft properly. Then there are some forms like form 1 where the inventors have to sign and assign their application. Then similarly in form 5, in form 18, that is for request for examination. As I told you, without a request for examination, your patent application will not get examined. So these forms are necessary, and like usually the attorneys are well aware of all these forms. As I told you, there are two types of applications: provisional and complete. And whenever we want to go to the foreign patent offices, we have convention application route, or we have PCT application route. So in India, we have 4 patent offices, like in our 4 metros: Delhi, Mumbai, Chennai, and Kolkata. So if you are from northern region, you file the application in Delhi. If you are from west, file in Mumbai. If you are from east, file in Kolkata. If you are from south, file in Chennai. So although like filing will be based on jurisdiction or the location, but these days patent office is very much open. So what they have done is that they distribute the examination reports equally. So there have been many cases where we have filed the application in Chennai, and the examination has been done by an examiner in the Delhi patent office. But yes, when you file it, you have to see where you are located. We can go ahead. So as I told you, searching is very, very important. As you will see in this cartoon, this person is coming to the patent office and showing a wheel. So he has reinvented the wheel. So any reinvention of wheel will not be patented. So anything which is known, which has been published, which is there in public domain, you will not get a patent for that. So that is why searching is very, very important. 25% of all the R&D efforts get wasted every year just because we have not done the searching properly. So avoid unnecessary duplication of experiments. Know in advance what are the technical issues with you. Determine what is the state of art, like what is existing. Maybe you should work over that. So searching part is very important. Maybe you can go to the next slide where where there are mentioned some websites which are free. Say for example, USPTO website. InPass is the Indian patent office website. eSpace is the European patent office website. So and one of the most easiest is Google Patents. You go to Google Patents, search for the issue you are facing or the problem you want to address. You will get patents which is free. Go through them, and then maybe develop your synopsis or your theory or your PhD thesis. So searching is important. And for searching, there are free databases also, like as I told you, USPT or InPass or eSpace or Google Patents. There are paid databases also, which are very, 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 very complex. And like if someone actually wants to launch a product, he or she will go for like paid searching, so that he can launch a product and he does not infringes any other patent. So go for searching. Go for at least students can go for free searching, and then develop your synopsis and your PhD thesis. Yeah, please go ahead. So as I told you, there are 3 criteria for patentability. As this figure will tell you. There are many fishes which are blue, but we can see there is one orange fish. So there is novelty here. So a process with catalyst or without catalyst. I have added a catalyst. I have made it a patentable thing. There is a novelty there. A pen with a cap, or 2 motors or a fan. I've addressed the novelty wala issue. But maybe when we go to the next slide, you can go to the next slide. You will see that inventive step is far more important criteria, because there are fishes, there are blue fishes, there is an orange fish which gives me novelty, but there is one more fish which has, you know, 4 fins. So other fishes, the fins are not visible, but here 4 fins are visible, or a spike is visible, which is not obvious. Like, there was no question that such fish would have you know, existed. So if we are able to you know, address these criteria of novelty and inventive step, we will get through. uh, so we will relate to the earlier example, a pen with a cap. But if I add a pointer to that, that may not be obvious to a person skilled in art, and it will sail through. So two motors with a fan may be novel, but if I make a turbine, add a turbine, and I make a windmill out of it, or I use it in a dam, it addresses a very big problem, and you know, so that is patentable. We can go ahead. So this cartoon will tell you that, you know, this person is trying to sell the lady a socks with 3 pairs of legs, you know, which is not possible, which is not industrially applicable also. So such a thing which is not industrially applicable will not be granted a patent, and we should not go for, we should not even try to get a patent for that. So that may be a waste of money probably. So we can go ahead. So these are various modifications of one single thing, which is a needle. One needle which has a head on the top, which we use in home. Another needle is where we have a hole at the bottom, which we use in the industrial things. Another needles are for surgery. So these are surgical needles which we will use while we do the surgery, so that we do not puncture the maybe the nerves, or the blood vessels. Various modifications of one single thing, and all of them are patentable. So next slide, please. Similarly, these are scissors. Some of them are used by a surgeon. One of them may be used by a tailor. One of them may be a pocket scissor. One of them may be a mechanical scissor. One of them may be used by a barber. All these are modifications of one thing, but they have changes. They have industrial applicability. They were non-obvious, and they were all patented. Please go ahead. So we'll go through some case studies quickly. Yeah, please go ahead. So, you know, as I've been talking, improvements and alternate solutions are very much patentable. So it's not that you have filed a patent on one thing, and if you see there is scope of improvement, you can file a patent on that. So this figure will tell you that earlier we used to have, you know, we used to write with feathers. Our Rishi Muni used to write with feathers. Then the kalam came up, where which was wooden kalam. Then a fountain pen came up, and that like, you know, evolved into a ball pen. And then we have such pens now which which have you know, cartridges in them, and which have disappearing inks also. One thing, so, for an attorney, all these are writing stuffs, are writing device, but all these are patentable because they have addressed various problems at various stages. These are improvements, but they have addressed problems at different stages, and that is why all of them are patentable. So alternate solutions and improvements are very much patentable. Please go ahead. Inventions can be simple. So you'll see in this cartoon that this person is eating himself and trying to feed his bird also. So, so it's not that necessary that a patent is a complex thing. Even, you know, we have had patents for post-it, or even for needles. So inventions can be simple. We can go for simple inventions also. Say for example, the James clip which we use in the to clip the pages, that also had a patent on it. Such a simple thing, only a wire modified, but that was patentable. So inventions can be simple. Please go ahead. This is one of the classic examples which we see most of the times when we get a pizza. So this tripod stand is a very simple thing. The utility of this is that it prevents the pizza from sticking to the top of the pizza box. So it was invented more than 30 years ago. We have a patent which is now expired. A very simple thing, very effective, and that is why it got a patent. Please go ahead. So Post-it, as I told you, so there is a story about Post-it that the engineer who made Post-it wanted to make a glue which was very hard to get off, but like it happened inadvertently that the glue he made was not sticking well. So he took it to his management, said that I made this glue but it's not sticking well, and they dropped the idea. But when the next management came up, they saw that yeah, there is a merit and we can actually take these papers off and on, and use it in a maybe research or pointing out things. They filed a patent for it, got a grant, and you can see each and every one of us uses Post-it. Please go ahead. So anyone can be an inventor. So maybe we can go to the next slide, which will give you an idea. So this is a patent for a special shoe system where a person can lean like this when he or she dances or performs on a stage. So next slide, please. So what is that? That there is a sort of a, arrangement in the heel of the shoe which will allow him to stick his shoe in the platform and he can lean. Next slide, please. So that you can see this notch in the figure 6, where he can fix his shoe on the platform. Next slide, please. Next slide. So this patent is with, like, it was granted to Michael Jackson. So the thing he used to show by leaning, he used to use this shoe for doing that action. So anyone can be a patent, can be an inventor. There is no bar. No one says at the patent office that you are from science, you cannot file in mechanical engineering, or you are from mechanical engineer, you cannot file in chemical engineering. There is no bar like that. Only criteria is novelty, inventive step, and utility. If you satisfy that, you get a patent. Next slide, please. So this patent application we had filed, this is for our Muslim brothers. When they do the wuzu, they need to wash their hands. So one of the inventors developed this invention, and you would have seen this now very much these days with this dispenser for sanitizers. So here is the application or wash basin where you can use your foot to dispense the water. So necessity is the mother of invention. So we should not think that this will go waste or anything. If you feel there is a potential, file a patent. Go to the next slide, please. So this patent we had filed, where we had filed a design also for the ophthalmic bottle cap and a patent also. So this cap had a gyration which allowed only 2 drops out of this bottle. So we could file a patent also for this and a design also for this. So there is a no bar that you cannot file a design for a patent. So you can do both the things. So when you develop a product, think that way, okay, maybe I can file a patent also for this and a design also. So next slide, please. So some common mistakes and misconceptions we can take it on. Next slide, please. So as I told you, don't publish anything. Keep your publication, keep your invention secret. First file it, then go for it. Don't miss the bus. If you have some potential invention, file a provisional application, get a priority date, and then keep working on it. Then another important thing, as we had talked, do proper searching, and don't underestimate your invention. Like as I was telling you, James Clip, such a small thing. So don't underestimate your invention. If you feel there is a potential, there is novelty, inventive step, and utility, file it. Next slide, please. Another thing is that when we file a application, the disclosure should be proper. A very important thing here is that we should distribute, like when there are 4 or 5 inventors, we should try to accommodate all of them. We should avoid like issues, ownership issues. Like I'll say that don't fight with each other, share the profits with each other. So I'll say these are some suggestions from our side. So maybe you can go to the next slide. For the people in biotechnology, you may be aware that if there is a patent on microorganism, you have to deposit that microorganism to some depository before filing a patent. So first deposit it, then file the patent. Maybe next slide, please. If there is an invention on some modified DNA sequence, then you need to give the sequence listing also for that, and how and where the mutation was given. So maybe for biotechnology and microbiology people, you need to have sequence IDs in hand. You need to have the proper cluster W arrangements or all the alignments in hand, so that you can show here is the mutation and here is my sequence. Next slide, please. Another very important thing is NBA permission. So NBA is National Biological Diversity Authority. So if you have any invention which uses biological resource from India, which could be a microorganism, or which could be a plant, or which could be an animal or their part, you need to take that NBA permission. Otherwise the patent office will not grant that patent application. So NBA application is very important, very necessary if you have used some biological material from India. Maybe we can go to next slide. We can skip this slide. So as you are aware, even the government is supporting the startups. So if you do feel, and your institute, like many of the IITs, even BIRAC, these are supporting the startups in a very good manner. So if you are startup which is not more than 10 years old, and your revenue is not more than 100 crore, you are eligible to be a startup. Get a certificate from the Department of Industrial Policy and Promotion. Register yourself as a startup. And next slide, you can go to the next slide. So next slide will tell us, like, if you are a startup, if you are registered as a startup, there is concession in the patent examination. You get expedited examination, you get facilitators, and you get free legal assistance. So if you are able to make your startup, you can avail all these benefits, like exemption of the fee, expedited examination. So maybe if you have some plans, please make your startups. So next slide, please. So as we all know, BIRAC is one of the important funding agencies. Then we have NRDC, TIFAC, BCIL, and every state has its own science council and their funding policies. So go to funding agencies so that you get best out of your patent. We can go ahead. Oh, one more slide, please. So there has been a change, and I'll say there are two important change that if you are from an educational institute, you are from a university, research institute, the government has reduced the fee for that. So earlier the research institutes and universities used to fall in a large entity status, and there was a bigger fee for them. But now that fee has come to the level of individual inventor. So the fee for filing an application for an individual inventor is 1600 rupees, and for a large entity is 8000. But now that fee for educational institute has come down to 1600 rupees. So whenever like if you are from an educational institute, please use this facility. And one very important thing that has come up in last 3-4 months is that if there are female inventors in your patent, then you can expedite your patent. So you can get the advantage of expediting your patent. So these are 2-3 important things which we can take in mind. Next slide, please. We can so these are strategies for filing patents internationally and management of patent portfolio. So we have been working with many of the institutes, CSIR, ICMR, and many of the companies also. So we have seen that working with the attorney is very important. So when we draft the application, when we draft the license agreements, when we draft the non-disclosure agreements, the help of attorney is very much required. Then we need to do market survey as to where we want to launch the product. So if my product is not capable of being launched in a country where I won't be able to sell it, so don't file in that country. So market survey is also important. Do a proper market survey, see where you can collaborate, And then manage your fundings well. We have seen many patents getting lapsed because there were no funding or they could not arrange the fundings. So maybe before that you plan ahead, you collaborate with the industry, try to address their problems, and align with the funding agencies so that you can prioritize, you can pay the annuities well, you can plan in which country you want to go. So maybe these are very important things. Plan well. Yeah, so please go ahead. These are just for fun slides. Maybe go ahead please. So this type of cycle, I think it, because it does not have industrial applicability, won't be patentable. So next slide please. So I do often ask a question on this slide: what do you feel, whether this is patentable or not? So many of the times the answer comes as no, because there are no round tires. But this is patentable because this is a exercising bicycle. So if it is capable of being used, it is patentable. Next slide please. These are the simple inventions. So whatever we'll see in the next slides are simple inventions. These are all patentable. So simplicity is not a bar to patentability. Keep that in mind. If there is a potential, please file it. Next slide please. So it's a beautiful chair for a grandpa, and the children also can sit on that. So it will be maybe you can file a design application for this and also a patent for this. Simple invention but patentable probably. Next slide please. So this biscuit pocket, a cup with a biscuit pocket, simple invention but patentable. Next slide please. So many a times we face this problem that when we pull this electric plug, the whole socket gets out. So maybe they have given a provision where there's a hole and you can pull it out easily. Simple invention but patentable. Yes. And next slide please. So this is just for fun, a device for making a French beard. Next slide please. Yeah. So this person can use this as a number. Most of the Japanese, they are very inventive. So probably this person is from Japan, and he's using this as a tie also, and maybe as an umbrella also when required. Next slide please. So what is the takeaway from our discussion today is that next slide. So if you feel there is a application, file a provisional application, follow it with complete application. And I'll say, if you want to go internationally, plan well in advance for your funds. Keep the market survey in mind so that you can think which country is important for you. I'll give you an example that any invention which is on tea, processing of tea leaves, that won't work in a country like maybe Antarctica or a country or Greenland where there is no tea. So we can't sell tea or a process there. So we will sell such a patent only in maybe in India or Sri Lanka or some African countries. So plan that way. Sign a non-disclosure agreement, because many a times it happens that your attorney or someone else may leak, or your licensee may leak something. Sign a non-disclosure agreement, and then proceed ahead. And as we had talked, do your search properly, use the search engines, then file your patent. And important thing is seek expert advice. So many a times I cannot prepare a good food probably, but if I go to Haldiram, I'll get good food there. So they are experts in that. They are or maybe if there is a Panchi Petawala, he is expert in making that thing. Go to an expert. So as we discussed, so if there is you don't have patents, a smaller fish gets eaten by a bigger fish, and bigger fish by even bigger fish. But if you have patents, so next slide you can go, you can fight it out. So if you have patents, any big company will they will refrain from touching you or taking you over. So it is very important to have IP in hand. So next slide. So thank you. Maybe this is what I can say. And if there are questions now or anytime, please feel free to come up.
Thank you, Dr. Pandey, for taking us or explaining the strategies and what are the PCT, how to file the PCT application, and what are the convention application, and what are the different strategies we should keep in mind when to file a provisional, and if we don't file a provisional application, so there is a need to file a complete patent application, because sometimes what happens, most of the startup companies think we have filed a patent application. They are not aware about the fact that there is a provisional thing and there is a complete patent application thing. So for us this was a great session, and we do have questions. Maybe I can read out, and
Yes.
I can see few of the participants has also raised their hand. Maybe I can first ask them. So Mr. Shivendra Singh, Amit, can you please unmute him? Shivendra Singh. In the meantime, I'll read out the another question. So Nikunj Bhagat has asked one question: why request for examination doesn't happen automatically? Why anyone has to request it? So this is the question from Nikunj.
So that won't happen automatically. So one thing is, there is a fees involved in that. You have to pay a fee to patent office, then only that will go ahead. Another thing is that, patent office has given you a large time, 48 months from priority to file a request. So in that, there is a chance that you may feel that, no, yeah, I don't have funding, or that, patent technology is going to lapse. It may not work. So you may drop that application. So if you don't file that request for examination, patent office will not pick that up, and that is why they have not made it automatic. So you yourself have window to choose whether you have to file or not, when you have to file, and whether we should go ahead with it or not. So if that is done automatically, you are gone. No, that will get published and you will lose the thing.
So hopefully Nikunj must have got his response, because there is always a need to file a request for examination, as it involves the fees to be paid to the patent office. So next question again has been it is again from Nikunj. I can see three questions from him. So is it better to file patent as an individual innovator, or after creating a startup in the company's name? So whether the it's all about the ownership, like who will have it? Yeah.
Depends. So if many things are there. So funding is one of the important things. So although the fees now is same of the startup as well as the individual, but maybe if you go as a startup, you can avail the benefits of expedited examination and all those things. If you go as an individual, that may not come to you. But if you go through an individual, there may not be ownership issues which may come up if you go through a startup. So it depends on your strategy, your need, your requirement. If you want to avail the benefits of, and there is a startup, it is registered, it is well funded, go through a startup. But if you have small funding, you want to take your time, then please, maybe you can think of going through as an individual.
Okay, so he has a one more question. Does the patent life, which is the 20 years, it starts from the priority date or from when it is granted? So
Yes,
yeah.
yeah. It starts from the priority date, the date on which you have filed the application. It starts from there.
Yeah. So another question again from Nikunj. If the provisional application expires, can you file another provisional application if the invention has not been published anywhere?
Yes. So a provisional application will never get published. Once we do complete, then only it will get published. So there are many instances when people file a provisional, they feel that, no, I am not been able to generate the data. I may not be able to file the complete. They drop it, file a separate application for that, and just because they want to avoid publishing it or letting it come into public domain.
So we have question from Ms. Priyanka Sharma. So she wants to have the information whether there are two things, like patentability aspects of the mobile application and repurposing of drug, whether these things can be patented as per the Indian Patent Act or not.
So as I told you, so if it is to a software per se, if you have developed a software per se, which is just a written instruction or an algorithm, that won't be patentable. But if you combine that software with a hardware, say for example, if you are able to show that my hardware is capable of working better because of this software, you will get a patent for that. So we do represent Google and other Qualcomm like companies, and they do get patents. But there we have to take care in mind that functional aspect is highlighted, and software per se as such won't be granted. And if talking about the repurposing, that will fall into the new use of a thing. So new use of a drug, or new form of a maybe not new form but new use. So that sort of thing is not patentable in India, that is patentable in Europe.
So one question is from Janaki. If we do modify some existing things like in food products, so can we get a patent for that?
Yeah, you can. So if maybe you are you have a basic component in you add some more 2 3 components there, and you are able to show that there is some unexpected property, there is some synergy between these things, you will be able to get a patent. So modification does not means that you just modify the chemical entity. If you add something, if you add some ingredient, that will fall under a composition. It will be patented if you are able to show the synergy and unexpected property.
So we have another question. One is for the financial assistance for PCT filing. Mr. Sachin has asked this question, and he has also one more question. Can you reshare the slide where searching websites were listed for patent? Okay. So he is asking about the list of the free patent databases, like where they can carry out the patent search.
Yes,
So
it's here.
So Sachin, if you can hear us, we will try to give you list of the freely available patent databases, and we can share the details with you. And for the financial assistance, as Dr. Pandey mentioned in one of his slides, there are agencies who provides the support for the patent filing. One of them is BIREC, also provides support for PCT, provisional filing, complete filing, and national phase filing. But for the BIREC, for availing the BIREC fund, you have to be a BIREC grantee. But there are organizations like NRDC, and if you are an academic institution, you can go to the TIFAC and you can approach them for the patent filing, PCT filing also. So we have question from Mr. Rakesh Kumar. What is the what is the trend of biotechnology patent in recent years? How many patents actually have been we have seen like it's increasing, or it's what is the current situation?
So
Basically,
if we
he's
see
asking about in India.
So you see the data, so most of the applications fall on, many of them will go to the electronics and mechanical domain. So they are the richest in that way. Then comes the pharma and chemical wale. Then comes the biotechnology. So the biotechnology lags mainly because of the things that there are many things which are not patentable in India, like method of treatment, new plant, maybe a new in cell line, stem cell, naturally occurring microbes. They are not patentable. So we have faced problems there. We also have the issues of NBA, as Dr. Vinita also would be knowing. So that is why we find that patents in biotech are lesser. But definitely because of COVID, many things have changed. Many of the people have become interested in filing patents in life sciences domain, especially after COVID, and like the kits for detection, or maybe new drugs or new treatments. So we are expecting that by next year the patents will rise in biotechnology because of this pandemic. We are hopeful that yes, it will rise because there have been problems, they have been addressed, and patents will come up.
So these were all the questions which have been raised by the participants, and so I don't see no more question from them. So thank you, Dr. Pandey, for taking out time, and it was a wonderful session. And I believe every participant who have attended this, they must have enjoyed it. And
Thank you, ma'am, and thanks for this opportunity. And like all of them can feel free to write to me. You have my mail ID, so
Yeah,
we are
sure.
available. Yeah,
Thank you so much.
yeah. Thank you, ma'am. Thank you.
Thank you everyone for joining with us.
Thank you, everyone. Yes, thank you.
Thank you.
Yeah, bye.
Bye.